Hello, my name is Ben Anthony, and today I will be talking about employment discrimination. A few things that we will cover today in my presentation are going to be the definition of employment discrimination, the history, the laws that actually protect individuals who are employees against the employers, covert discrimination, looking ahead to possible laws that have been amended or possibly could be amended in the near future. And then we will take a look at the references. The definition of discrimination is the act of making or perceiving a difference, the act of discriminating. Psychology is the process by which two stimuli differing in same aspect are responded to differently. The quality or power of finely distinguishing, the act, practice, or an instance of discriminating categorically rather than individually. Prejudice or prejudicial outlook, action, or treatment, which would be racial discrimination. So there's actually a very important matter to discuss here is the difference between discrimination and prejudice. Prejudice is actually a perceived opinion that is not based on reason or actual experience. When we dig a little deeper and look into the law definition of prejudice, we see that it states harm or injury that results or may result from some action or judgment. Now, when we take a look at the difference between discrimination and prejudice, we see that a prejudiced person may not act on their attitude, whereas discrimination is the behavior or the actions, usually negative toward an individual or a group of people for that matter. Employment discrimination has come a long ways over the years. The Equal Employment Opportunity Commission was actually created in the Civil Rights Act of 1964. And the abbreviation for that, which is pretty well known today around the employment sector, is the EEOC. This act not only addressed discrimination in employment, but also voting, public accommodations, and education. And how this came about is the law was formed due to an increased unrest that was surrounding racial discrimination and segregation witnessed in the 1960s civil rights protests. The world watched as demonstrators were attacked, beaten, even sprayed with fire hoses, and then arrested and jailed. The images actually tarnished the nation, and the need for civil rights legislation was needed to address the unrest in the country. When we take a look at the laws, we can see the first is Title VII of the Civil Rights Act of 1964. This law actually makes it illegal to discriminate against someone on the basis of race, color, religion, national origin, or sex. This requires employers, to reasonably accommodate applicants and employees' sincerely held religious practices, unless doing so would impose an undue hardship on the operation of the employer's business. The next we have the Pregnancy Discrimination Act of 1978. Now this is a very interesting act. This law actually amends Title VII to make it illegal to discriminate against a woman because of pregnancy, childbirth, or medical conditions that is related to childbirth. Now, when we think about this, there's about 75% of the 68 million women working in the U.S. will become pregnant at some point in their lives. So this is a very important law that employers must follow. The law was actually a direct response to a United States Supreme Court, which was General Electric versus Gilbert, which held that pregnancy discrimination was not a
form of sex discrimination, which was not under the Title VII Civil Rights Act of 1964. And in this law, actually, employers must have 15 or more employees in order to have that protection. However, there are some states that have laws that cover employers that have 15 or less employees. Depending on your state, it could vary state, and it does. You may be protected even if the company that you work for has 15 or less employees. Next, we will move on to the Equal Pay Act of 1963, which is also abbreviated as EPA. This law makes it illegal to pay different wages to men and women if they perform equal work in the same workplace. Now, this law was actually signed into a law on June 10th of 1963 by John F. Kennedy as part of his New Frontier deal. The next, we will take a look at the Age Discrimination in Employment Act of 1967, which is also abbreviated as ADA. Now, the Age Discrimination in Employment Act, actually, this law protects people who are 40 or over from being discriminated against because of their age. Now, this law was actually signed into a law by President Lyndon B. Johnson, and it also prohibits discrimination in hiring, promotions, wage and termination of employment, and or layoffs. The next, we will get into Title I of the Americans with Disabilities Act of 1990. And this law makes it illegal to discriminate against a qualified individual with a disability. Private sector and state and local governments do have to abide by this law. And the law also requires that employers reasonably accommodate the known physical or mental limitations of a qualified individual with a disability who is an applicant or is an employee of that company. Unless the accommodation would impose an undue hardship on the operation of the employer's business. We move on to sections 102 and 103 of the Civil Rights Act of 1991. And this law actually amends Title VII of the ADA to permit jury trials and compensatory and punitive damages awards in intentional discrimination cases, which is very important. Next, we'll go on to sections 501 and 5 of the Rehabilitation Act of 1973. This law itself makes it illegal to discriminate against a qualified individual with a disability in the federal government. Now, as we mentioned earlier, we did say in the it was for employers, but now this is specifically regarding the federal government and positions there. The law requires that employers reasonably accommodate the known physical or mental limitations of a qualified individual with a disability who is an applicant or employee. Just like the Act, again, this is in regards to the federal government employment. Unless, again, there is this, unless the accommodation would impose an undue hardship on the operation of the employer's business. We will look now at the law, which is the Genetic Information Non-Discrimination Act of 2008, which is also referred to as GINA. This law prohibits discrimination on the basis of genetic information with respect to health insurance and employment. Now let's go ahead and break this down a little bit. The genetic information includes information about an individual's genetic tests and the genetic tests of an individual's family members. Information about disease, disorder, or condition of an individual's family member, such as a family medical history, is what this law is referring to. Now, before we jump ahead, I do want to talk about this for a little bit. The laws that we just previously discussed, all the laws that we previously discussed make it illegal to retaliate against a person because that person complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or a lawsuit. And that's something very important to take away. Next, we will talk about covert discrimination. And covert discrimination is hidden or subtle discrimination. Such actions are actually hard to prove since they are hidden by rational or non-discriminatory reasons. The characteristics of covert discrimination may be intentional or unintentional. Behavior is clearly visible but rarely noticed. They involve both verbal and behavioral actions, and most are related to individual perpetrators. And some examples of covert discrimination is not hiring a person because he or she may be gay. An employer hiring somebody of the same race, even though somebody of a different race has better qualifications. Next, we have overlooking somebody for promotional opportunities. However, they're given a rational reason for the actions that were taken by the employer. Assigning someone undesirable job duties could be another example of covert discrimination. And male colleagues treating their female counterparts differently, basically being extra polite with them. And this is something that is seen around the jobbing industry on a daily basis. Just because, like I said, covert discrimination is hidden or it's subtle, so it's actually very hard to prove. Now, when we talk about looking ahead for employment discrimination, there has been, with the advancements in technology, there have been things that have been popping up that have, been targeted recently. One of those is transgenders. And Title VII of the Civil Rights Act of 1964 actually prohibits sex discrimination in employment. Now, courts, U.S. Justice Department, and the EEOC agree that discrimination because an employee or job applicant is transgender or gender non-conforming, as it's also referred to, constitute as sex discrimination. Now, state and local laws in many jurisdictions also prohibit discrimination based on gender identity or expression. And many states actually have such explicit laws currently, and more states are expected to add laws that enforce gender identity or expression. State and local government employees are protected by state constitutions and laws prohibiting discrimination on the basis of sex in employment. And there is some executive orders in various states explicitly prohibit gender identity discrimination in state employment, and more states are expected to actually add executive orders. So that can be something that we could possibly see here in the near future as we're looking ahead in employment discrimination. Now, federal civilians have additional protections in this arena as well, and different procedures for complaints. The federal government has issued guidelines for transgender workers. Next, which is also another topic that has been brought up as of late, is bisexual, gay, and lesbian employees. Now, the EEOC has actually taken the position that existing sex discrimination provisions in Title VII protect bisexual, gay, and lesbian applicants and employees against employment biases. Now, a growing number of court decisions have actually affirmed the Commission's interpretation of Title VII. And one that I want to talk about in particular is Heller versus Columbia Edgewater Country Club. Now, this is a sexual harassment case brought on by a lesbian employee who was subjected to negative comments about her sex life. So that could be, her fellow coworkers, maybe using derogatory terms or talking about her sex life to her or behind her back, where maybe she overheard. And the evidence in the case actually was found by the court to be sufficient to state a claim for violation under Title VII. So this is something that could also, just like transgender, be covered under Title VII. Now, when we talk about areas that are not currently covered by federal law, in the future, we have obesity, which is one that could be covered, attractiveness, and social class. I know a lot of times, depending on your social class, maybe, that could be added into employment discrimination if an employer is discriminating against an applicant or employee because of their social class. So should they be covered under federal law? Well, that is up to debate, and there has been some case law more around the obesity discrimination. So it is a possibility. It is a possibility that maybe there could be an amendment to the employment discrimination laws. Now, that wraps up my presentation today, and in front of me is the references that I used to complete this presentation. Now, I can tell you, if you do have any questions in regards to this, the EEOC website is actually a very, very well-documented, very good information on employment discrimination. Well, I thank you for your time.